So this video is for the person that posted and wanted to know about what to expect for a 2-day trial that's coming up. I believe they said it was in a couple of months, but for any of you that are dealing with trials, so we're going to talk about trials and what to expect and what you should be preparing for it. Now, I caveat this by saying that this is probably mainly for people who represent themselves, because 70% of people in family court represent themselves. But it also, even for those of you who are represented, it gives you an idea as to what to expect for a 2-day trial. One of the things that I notice quite a lot actually is that people say to me, well, no one told me what to expect. No one told me how to prepare for it mentally or what to do practically. So here are a few things that I think are going to help. So first of all, the order of service, if I put it that way, tends to be a lot more formulaic than it does with the shorter hearings. Obviously, the court put a huge amount of emphasis on pre-court negotiations, and heck, I absolutely advocate that. I am literally the definition of a broken record by now, but if things can be agreed, it makes things work a lot better. But I'm assuming this is in case that you've got to court an hour beforehand if it's on day 1, day 2, day 3, but if day 1, get there early. Always meet an hour early. I always do that. I always meet people an hour early. Not only does it get you settled in, maybe get a consultation room or a Zoom call if it's kind of online, but it gets you settled and prepared and in the zone, perhaps some scripting as well. And also pre-court negotiation. This is especially important when you've got a trial, because a trial will either be a contested hearing, whether it's a finding of fact, or if it's a final hearing and you're trying to negotiate, I don't know, finances or child arrangements, etc. So here's how the order of service typically goes to, assuming, of course, that the pre-court negotiation hasn't worked. And by the way, even if you feel that you might be kind of too close to an agreement, it's not a fait accompli until the court has stamped the order. I've seen people be close to agreement and then for it all to be thrown up in the air on the day of the trial. So just bear that in mind. Okay, so when you're going into trial, first people who are going to give evidence are the professionals. So this is going to be CAFCASS, local authority, NIAS, if whoever's done the report traditionally, they're typically the ones that are going to give evidence first. And it's your opportunity then to challenge that evidence if you are indeed challenging it. Or sometimes even if you're not challenging it, you might want to just sort of ask some questions that kind of reaffirm your position / their position, because if you are in agreement with the professionals, then you might just want to just bolster that view to make sure that no, we're doing this. Secondly, it's going to be any other witnesses. Now, if it's a couple of days trial, you may or may not have witnesses. But if there are witnesses, and you'll know if there's witnesses, by the way, because there would normally have been a pre-trial hearing or a hearing before the trial itself to kind of timetable how this is going to go down. Courts often overcompensate, I think, for if people are litigants in persons, because traditionally they take longer to answer questions, ask questions. So there's more time that can often be allocated. I have seen the reverse actually, and I sometimes think the court timetabling hasn't always been the best, but for the most part, a good court or a good judge or good magistrates will usually try and allocate more time if parties are litigant in person. So you've got professionals first, the witnesses second, if there are any, and then finally the parents. And by the way, that will go in no particular order. So whether it's mum, dad, or parties A and parties, it doesn't matter, but the court or the judge will decide kind of who goes first. It doesn't really matter. But it's whoever's going first, you're just on the stand giving evidence. And I'd always say that it's really useful to have someone guide you through being prepared for on the stand, whether you're litigant in person or not, because that can feel, well, stressful. These things are stressful. Let's make no bones about this. Going to trial is stressful. Hence why I always say, if you can agree things beforehand and avoid going through all of that palaver, brilliant. But I understand that sometimes that isn't always helpful. It isn't always the case, and you're going to need the court to step in and make that decision. So be prepared for being on the stand. And then that leads me then to the prep, because sing it with me, the magic is in the prep. Before the hearing, don't forget, 95% of this work is already done before you step foot into that courtroom. So somebody is going to need a bundle. Now, if both parties are litigant in person, sometimes magistrates tend to do this. They say, well, the magistrates will prepare the bundle. What I see though with that is that parties don't see the bundle. So, and it's really useful. Bundles, I'll do a whole separate video about bundles, but you're going to need a bundle. It's very useful. It keeps everything in one place. And when you're talking and challenging a witness on the stand, you can take them to the relevant page. Would also say, if there's allegations of domestic abuse, proved or not, by the way, then the person who is alleging allegations of abuse will not allow to be questioned by the other party under Practice Direction 12J. So sometimes the court will go around that by saying either we'll have the alleged, I'm absolutely putting that in alleged, okay, the alleged perpetrator to provide the court the questions in advance, and the judge will ask the questions. Sometimes Mackenzie friends, good Mackenzie friends, may get rights of audience. I've had this happen quite a lot. Or the court will allocate something called a QLR, Qualified Legal Representative. They are like rocking horse poop, just saying. I have seen them, but even then, there's a whole wide range of them. You not often get allocated those until lastminute.com, and very often they're just reading out your questions anyway. So have cross-examination questions prepared in advance. I mean, even good barristers and solicitors. I've seen really, really good advocates. They don't, some of them are great at improvising, a lot of them are, but for the most part, they are scripted. They have scripted themselves. There is a plan that they are following. So follow suit and make sure that you have your questions. Now, you are probably going to need help with cross-examination questions. Cross-examination questions is an art. It really is. And you have to be relevant, because if you're just there trying to question your ex to make out that you're a liar, you're in the wrong arena. You're there to challenge their evidence so that it's relevant to the case. So if it's a child case, for example, you're kind of proving and doing cross-examination questions, usually in line with the welfare checklist. Again, I can do a whole separate video on cross-examination questions, because that's an art in itself, and it's certainly taken me 17 years. And even now, I'm still learning, I'm still perfecting, and I've been doing this for 17 years. So have your cross-examination questions ready for the author of any report, so any professional that you want to challenge or confirm with or consolidate with, and certainly for the other party. The other thing you're going to need to do and prepare in advance is closing submissions. That's tying up your position. Now, that's not repeating. Well, there is going to be, you are going to feel like there's an element of repetition, because you have to be, first of all, nothing if not consistent. So you're going to be saying the same things in the paperwork. You said the same things probably to the professionals. And you're probably going to say the same things on the stand, as you're going to tie all that up. You're going to tie it all up in a nice, neat package. Say, look, here is the case. Here is the evidence you've heard. And again, you'll already know what the evidence is put before the court, because it's been there for a while. And very often people just repeat themselves on the stand for the most part, and you're just trying to challenge and tear that apart a little bit. So you're going to have closing submissions. So in advance, effectively, you're going to make sure you have three main things ready ahead of a trial. First of all, you're going to need a bundle, whomever prepares it, and I could do a whole video on that. You need a bundle, you're going to need cross-examination questions, and you're going to need closing submissions. And then finally, just a bit of mental preparation for you, because you guys who are going through this, I make no bounds about this, but this is really stressful. So make sure you have your squad. I say this all the time, but make sure you have your squad ready. Be prepared for the questions that are going to come your way, and have the answers ready. The questions aren't going to come as a surprise. I mean, maybe the delivery may be coming as a surprise. I mean, sometimes if you have quite a hostile barrister, that might feel quite intimidating. It's going to feel intimidating, okay? So you need to keep calm, because they're going to push your buttons. I say this all the time. I said this in a video just gone, that it is an adversarial arena. I hate the fact that it is, and I try and make sure that, certainly for my clients, that they are prepped and primed as much as possible. So yeah, make sure that you are prepared for the stand, and that whatever calming techniques you have inside, whether you're doing Tai Chi, meditation, whatever you need to kind of center yourself, and make sure you've got those people around you to support you through that. That's a big plus. Let me know in the comments below, what have I missed? How have you dealt with it, and how are you going to deal with it? I hope this helps.